it has impacted and is going to impact each and everyone. This is the most important part of a business in the world where majority business are done online. You collect lot of information, personal data, how you protect, it's your responsibility. There were laws, there were regulation, but this government is trying through these acts and rules to make it systematic, more control. And if you open the paper continuously, now the talk is that the timeline, because see, this act and rules partly is implemented and slowly it is started implementing. It has impact and it will have quite impact on small and MSME sectors and startup. So they are concerned about the cost. With this view, such an important topic we have taken as our today's presentation topic. Our presenter is Ms. Kinjal Mehta, Senior Associate Mehta and Mehta, and our panelist is Mr. Ibrahim Khatri, IT professional. Thanks, and is very intelligent. To be honestly formally introduced, Mr. Ibrahim Khatri is the co-founder and CEO of Privacy Solutions, a digital governance and data privacy firm helping financial institutions and fintechs build trust, compliance, and resilience in the digital economy. With over 20 years of experience across financial services, data privacy, and technology risk, he has advised leading global organizations including NPCI, Citigroup, BNY Mellon, Zurich Insurance, and Qatar National Bank, where he served as a data protection officer leading enterprise-wide GDPR implementation. A former leader at EY, KPMG USA and India, and PwC, Mr. Ibrahim specializes in privacy governance, AI, and cybersecurity risk and regulatory compliance. He is a fellow of Information Privacy and IAPP certified and is very widely recognized for his practical and forward-looking approach to digital trust and responsible finance. Welcome, Mr. Ibrahim. Thanks for your time.
Thank you, Ms. Tripti. Thank you for the introduction.
Our presenter is Ms. Kinjal Mehta. Ms. Kinjal Mehta is a chartered accountant and company secretary. She previously gained experience in EY assurance, auditing prominent private sector banks, and contributed to M&A transactions with EY strategy and transaction advisory team. She also worked with Blacksoil Capital, a venture debt fund, underwriting investments in growth companies. Currently, she serves as a senior associate in Mehta and Mehta's IPO team. Our moderator, everyone knows, our own Mr. Bala. With this, I'll request we thank all our panelists of today's webinar for joining us on our knowledge sharing journey on behalf of entire team of Mehta and Mehta. I'll request Mr. Ibrahim to say a few words on the topic, then Mr. Bala, and then Ms. Kinjal, you can start your presentation. Over to Mr. Ibrahim, please.
Thank you, Dipti. Thank you for the warm introduction. I'll just begin saying that this is a new, a completely new way how organizations have to think, right? And I'm saying this with, I know you mentioned that India has had some kind of IT Act or SPDI rules earlier, like 2011, but there has never been any fines associated. Nobody has done any kind of data governance or data privacy programs. And I think it's more from a culture, awareness, training, and letting people know that privacy has to come into the DNA of every employee. It's not, whoever's processing personal data has to, be trained on it. Second, the most important thing is that I was implementing the GDPR for Qatar National Bank, and all European companies have had some kind of privacy law since 1990s. They had a 2-year deadline for GDPR, but still organizations were really struggling till the last minute. India has, first of all, a little bit uniqueness the way they have managed consent. So I think a lot of people will realize that a lot of time is required for assessing and doing an implementation. And I think it's just going to be a game changer the way after the board is put up. The government is already putting a couple of fines before even the board has completely been formalized or the deadline has come. I'm sure everybody's read about Meta, right? And Meta just got fined and they're taking them to court. But yes, it's a whole new era, right?
Thank you, Mr. Ibrahim. And we will surely get benefit of your experience during presentation. Please share your experience as and when you want, and you can interrupt the presentation. Thank you. Over to Mr. Bala, please.
Good morning to all of you. I have a great pleasure in welcoming you all on my own behalf and also on behalf of Netha and Gita. As both of our panelists said, it's a very quite new topic, which has actually come only in the last year, 2025. Partly implementation started, implementation spread over till next year. I believe if it is May 2026 is the deadline. But we are in the implementing process and the learning process. But however, as Ibrahim puts it, yes, there were laws earlier, especially for the corporate sector, even under the common law, the confidential information should not be shared, it should be kept, privacy should be maintained. All those things were there, but there was hardly anything on those when it come to the implementation, when it's looked at it. But personally, if I go through this law, the law as reading, it appears to be simple. Rather, it uses the word when it complains to the complaint, because being a company secretary, I look upon what are the complaints. Because as you are aware, as a company secretary, we are having a duty bound to ensure compliance under all the applicable laws. Then one more law gets added, DPDP Act. So from the compliance point of view, if I look into from the company secretary's point, it says the law is compliance is made in the very subtle system. That means simple, accessible, rational, and actionable framework. That's what it says. But as it's reading, it is not that simple, because there are many issues. Today, as Dipti puts it, everything is done on online. All the things are stored in soft copy. No more what you call physical copies. So what happened? The data actually becomes an asset to the company actually today. When the asset to the company, then the safeguarding comes to the topmost people, that is board of directors, who are to take the responsibility to ensure it is well protected. That is one thing. Second thing is, as we go on, Kinjal will take us the various terminology. What is the data protection? What is the individual data protection? What is the processing and all those things? We think we collect the data, we store it. Even the law says, even collecting the data and storing itself is also a processing. So those sort of the intricacies are there. So we have a great way to learn the things, correctly interpret the terminology, because we are good at interpreting the law, but we have to see very carefully and see while coming to the implementation. There are a lot of scams and misuses and other things that are happening in the data privacy, which we are watching. A lot of n number of cases have already been reported also, because especially when the people are all giving outsourcing and the KYC information and other things and all. So there are many things are there, and we are still in the learning process. I am also looking forward from the IT expert today, more knowledge to know. So I'm looking forward this webinar very eagerly to learn more things. So I'm very sure Ibrahim will be sharing his personal experiences, because yesterday I had a small interaction with him. I can understand the tremendous amount of the knowledge, the job, what he has been doing. We could not have get the better panelist than him pertaining to this particular topic. I would say that. That is the thing. Looking forward to listen from him. Kinjal, over to you, please.
Thank you. Can you start, please?
Yes, let me just share my screen. Yes, good morning, everyone. So today's topic is again another hot topic, which is Digital Personal Data Protection Act and rules. We are going to take an insight into this new legal framework that is in the process of coming into place in India, which is one of the fundamental changes when it comes to the developments in the legal world that are happening right now, keeping pace with all the tech and data related updates that are taking place today. So with that, I'll start with my presentation. Now, starting with why was Digital Personal Data Protection Act and its rules required? How did we get here today? So, starting with before this Supreme Court judgment, just where India's Supreme Court declared privacy to be a fundamental right under Article 21 of the Constitution, which is the right to life and personal liberty. This included informational privacy also, that is having control over personal data. But this judicial recognition did not automatically create a legislative framework. That meant that there was no clear enforceable rules that defined what counts as personal data, how and when data can be collected, used, shared, or deleted, and various rights and obligations of individuals, like who could access, correct, erase before this particular act. Now, this gap left privacy rights unenforceable in practice. So, there was a constitutional imperative to translate the right to privacy into an operational law. Coming to rapid digital transformation, India's digital economy, including e commerce, mobile apps, digital payments, Aadhaar linked services, and social networks, expanded enormously over the past decade. Billions of Indians now transact online, share information, they're on social platforms, and depend on digital IDs today. The implication for this is there was vast volumes of personal data that are generated, stored, processed, transmitted daily. This includes sensitive personal data such as biometric identifiers, financial details, health records, location, etc. Without a robust legal framework, this data was very vulnerable to misuse, online transfers, etc. Further, there was a rise in data breaches and unsafe practices. India saw a growing number of high profile data breaches where personal information companies and organizations often lacked clear data governance standards. There was no uniform rules mandating data breach notifications, consent requirements, or accountability. This made individuals susceptible to identity theft, fraud, and economic exploitation. A law with clear security breach reporting obligations plus accountability mechanism was a dire need of the day. Then, before 2023, India's data governance, data management was governed mainly by the Information Technology Act 2000 and its rules. Section 43A of this act required reasonable security practices but did not define the data categories, consent rules, user rights, and penalties when it came to maintenance of these reasonable security practices. Other guidelines from other regulators such as RBI, IRDAI, there were requirements under those laws, but they were very sector specific. And there was no uniform legally enforceable national standard. Further, global standards were moving ahead of us. As global privacy frameworks like the EU's General Data Protection Regulation or GDPR, which today has become the benchmark for when it comes to data protection regulation, and our this act has also been inspired and from this particular framework. It With this, India faced pressure to align with international norms to allow for cross data flows. Multinational companies processing Indian user data needed clear legal obligations to comply with global standards. Strong privacy laws built trust with users and investors, helping India attract digital investment and innovation. A data protection law became important not just for rights but also economic partnership in the global digital economy. Further, a modern data law needed to provide individuals with meaningful control over their data. Before this, citizens did not have control over their own data. The requirements when it came to consent, access and correction, deletion, limitations on data retention, profiling, and how it was used didn't exist before.
Kinjal, are you
Without
still
such
in the
rights,
Kinjal, are you still in the first slide? Because slide is not changing.
yes, I'm on the first slide.
Okay, no problem. Oh, no problem. If you're on the first slide, it is fine. If the slide is not changing, then I have a concern. Yeah. Go ahead. Please go ahead.
Individuals, citizens did not have any recourse when their data was misused or mishandled. Further, there was commercial misuse of data. Businesses increasingly relied on data for targeted advertising, automated profiling, behavioral insights without transparent consent. There was manipulative data practices, exploitation of user information without explicit awareness or choice. There was lack of transparency. Further, instances of political misuse where unauthorized collection and use of personal data for political activities or campaigns was being used. There was requirement for stronger legal safeguards against non-consensual data harvesting. Now, all of these issues, this particular new act has tried to address, and we will look into how they are trying to do that. Coming to two basic concepts when we are looking at this particular act, one is data privacy and the other is data protection. Now, data privacy is a fundamental human right. Like I mentioned, it was identified as a fundamental human right in the landmark judgment of Puttaswamy. Whereas data protection is a regulatory operational framework. It is a regulatory framework that the government is trying to put in place today. Data privacy deals with individual dignity, autonomy, control over personal life and choices. It answers the question, what part of my life should be free from intrusion? And it's more normative and value based in nature. In contrast, data protection deals with personal data during collection, processing, storage, sharing, and deletion. It answers the question, how must information about me be handled? So, data protection is more technical, more procedural, and enforceable in nature. While data privacy, like I mentioned, is a fundamental right that comes from the Constitution of India, data protection is a statutory right which comes from a statute, which is your DPDP Act. Data privacy is a broader concept which includes bodily privacy, spatial privacy when it comes to where your movement is, decisional privacy, freedom of choice, beliefs, informational privacy, which is your personal data. And not all of these privacies, data privacy involves data. Whereas data protection is a much narrower concept. It's actually a subset of data privacy. Protection issues relate to privacy, but not all privacy issues involve data protection. Now, this particular act is applicable within India, and also it has extraterritorial reach. It is applicable outside India if such processing of data is in connection with any activity related to offering goods or services to data principals, that is, citizens within India. So, if a company is dealing with.
Kinjal, can you go to the earlier slide just to. So that means data privacy, which is fundamental right, is our data, our information. And you get protection if it is processed by somebody, and which is statutory right. Am I correct?
So data privacy is not limited to data only. So you have the right to not be surveilled, by someone who is standing outside your home and things like that. So that's a broader concept. But when it comes to data protection, you're talking about personal data and the right to having more control over how that is distributed.
Ibrahim, you may like to add something
I
on
hope
this.
that.
Ibrahim, you're on mute.
Sorry. So yeah, so as drawing parallels, data protection is more coming from the subject of like cybersecurity, like protecting the data, right? While it's in a different life cycle, like when you're collecting, sharing, processing it, what are the controls, data protection controls you are applying to safeguard the personal data is more personal data, and data privacy is a more broader concept.
Okay, thank you. Yeah, sorry, Kinjal, go ahead.
Right. And like I mentioned, data privacy, even though it was a fundamental right, there was no kind of law rights in this particular right in a better manner. Whereas data protection with this DPDP Act, this one part of data privacy, which is information privacy when it comes to personal data, you're trying to enforce that in the country.
Okay.
I mean, every country has had some kind of a data privacy law. Like US has had, they have a separate law for called HIPAA for healthcare. Granby Reach, which is used by all the banks. Certain states have a privacy law. Before GDPR, EU had so many different kind of regulations about privacy, but India has never had like a typical, right. So this is completely, not only defining the framework like policies and procedures, but also from an engineering perspective, a lot of uh, things are involved that need to be done by organizations.
In fact, as you rightly say, Ibrahim, I remember I visited the UK about 30 years back. I understand from them, asking somebody, what is your age? That itself is looked upon interference in the privacy. That is looked upon, offensive way of putting the questions.
Correct.
Yeah, that
And
is what I
here we
learned.
like to overshare. So I'll take a couple of examples, right? Even if you go to like an ATM machine in India, the guy behind you or a bank counter, the guy will come right behind you, right? I mean, they'll look into stuff. The privacy as a culture is not there. So I think that is the main idea. A lot of people say, why do we need this? But we definitely need it for many things. I'll take a very small example, right? There's a fintech company. It was in the news recently. There was a BBC documentary about it, right? They were specializing in giving loans to second tier and third tier cities, from 2 lakhs to 5 lakhs, and they had enough data about people who really needed money very urgently. And at the time of signing up, they would basically take so much of their data. They would take data that is not required. There was no lawful business purpose for them to take that kind of data. That kind of data is your access to your phone book, access to your contacts, your location, your camera, all that. There's no business purpose, but they were taking all that information and using it for other kind of purposes, right? If the loan wasn't paid on time, then they would call them up saying that we know where you are, we're gonna come, right? This is a documented thing that's happened in India a couple of times, but there's no data privacy law, right? So now organizations can't even collect any data that they don't have a business purpose for. So that's one of the biggest exercises that organizations have started to do is basically stop holding the data that you actually don't need. Delete the data that you don't have legal purpose for, right? That's a whole, you have to go on a data diet because organizations have collected so much data and data about data, like metadata, where they have no business purpose, right?
In fact, we recently was a news item about the WhatsApp. Everybody, you don't have the business to use any of the private data, etc. If that is the case, please quit this country.
Yeah.
That was the harsh things which have been
Because-
made by the observation by the
Yes,
courts.
because
Yeah.
Meta as a company, they have different privacy policies for different countries which has privacy regulation. Just because India doesn't have that regulation, for example, they're sharing data very freely between Facebook, Instagram, and WhatsApp without you consenting to that, right? How they use that data, how they process that data, that's a different subject. But just because we don't have that law, they are taking advantage of that. That's why the Supreme Court is also trying to make some judgments. Some examples.
Okay. Yeah, Kenya, go ahead.
Yeah.
Somebody is
No,
actually putting a question.
Bala,
Do it cover?
Bala, I
yeah.
think just one
Yeah.
question. We panelists will discuss, but I think
No,
we cannot take
I'm not taking a question.
Uh,
Because here, when you say people are collecting the data more than what is necessary, it is relating to that. Someone is actually asking, do it cover any accessing location and the contact access of the persons whenever we are taking? Because why we are booking the Ola through the application? That's what he is asking.
yeah.
Yeah. So coming to applicability, it is applicable within India. All the personal data that is collected within India by Indian companies for uses in India. Over and above that, it is applicable outside India too. If such data, personal data, relates to principals or individuals and citizens within India. So any foreign companies collecting data on Indian citizens is also covered under this act. Coming to digital, so now this act also limits itself to digital personal data. Now, this digital personal data, which is collected in digital form or collected in non-digital form but subsequently digitized. So all in all, it limits itself to digital data only and not all the data. Uh, Further, there are certain exclusions from applicability when this kind of data is used for personal or domestic use. If this data is publicly available, then if it is used for state instrumentalities, for sovereignty, security of the state, public order, research statistics, then the government can has the power to exclude certain startups if they feel necessary, etc. Coming to the timeline for its applicability, some of it is immediately applicable, which was 13 November 2025, which is definitions and the establishment and constitution of Data Protection Board. Now, this since November 2025 is kind of just laying down foundational work for further implementation of the Act. 1 year later, which is November 13, 2026, regulations with relation to consent manager, which is a concept we'll cover later, will become enforceable. And 18 months after the notification, which is 13 May 2026, the full act and rules will be enforceable. Now, let's dive into key definitions and concepts under this particular act. Now, when we talk about personal data, who does this really belong to? Does it belong to the person whose data it is? Does it belong to the company that spends time and effort collecting this data? Does it belong to the government that is trying to do certain surveys, etc.? The law answers this question, which is this personal data belongs to the person itself, which is the principal, to whom this particular data relates. Now, what is this personal data? Personal data is defined as any data about an individual identifiable by or in relation to such data, which means any data about an individual that can be traced back to the individual, or it can identify an individual, or is it related to that particular individual. Let's look further into that. So this identification or in relation can be directly or indirectly. Now, directly you can identify an individual through name, mobile number, Aadhaar, PAN card, device IDs, etc. Name, mobile number, Aadhaar card, PAN card, etc. But something like a device ID or a IP address or something in silo may not be able to identify a particular person. Now, indirectly is when certain different data points point to a particular person and related to a particular person, which then turns into personal data. Now, this act covers um, all types of personal data. It does not essentially define sensitivity of data. It covers all personal data when it comes to a particular individual. Now, coming to processing. Now, processing is another definition and concept: operation or set of operations performed on digital personal data, and includes operations such as, and it lists down a number of different processes that can take place on a particular data. So any kind of process, so any of these kind of processes that you carry out on a set of digital personal data, that is referred to as processing under the Act. So, for example, asking for phone number in a particular form that a person is filling out, is that processing? Yes, it is collection of data. Storing Aadhaar in a database is storage, which is again processing of data. Analyzing purchase history, which is use of data and hence again processing of data. Sharing data with a cloud provider is disclosure of data, which is again processing of data. Running algorithms on user data is again processing of data. Profiling users for ads, it is combination and inference of data, which is again processing of data. Deleting old customer records, which is erasure, which is again processing of data. So all of these different activities and operations that take place on digital personal data refers to processing under this act. Coming to digital principle, one of the main entities under the law, which the law is essentially trying to protect. Now, data principle means the individual to whom the personal data relates. There are certain additional protection provided to a child. So, when there is a child involved, then this includes parents or lawful guardians of such child. If a person with disability, then again the lawful guardian acting on behalf of this disabled person. Let's look at certain examples of data principle. A customer using a mobile app is a data principle. An employee whose HR records are processed is a data principle. So let's look at this again. And all the data that companies hold for its employees are also covered under this act. A patient whose medical details are stored digitally is also a data principle. This is one of the most important definitions under the code. Coming to data fiduciary. Now, this is again one of the other very important entities under this act. Now, data fiduciary means any person who alone or in conjunction with other person determines the purpose and means of processing personal data. Now, if there is an entity or an individual or an LLP, government departments, public authorities, NGOs, etc., who is collecting data and determining the purpose and means of processing data, then that's a data fiduciary. And once you become a data fiduciary, obligations and responsibilities are put on you under this act. Let's look at certain examples. And e-commerce platforms,
I'll
an
just add
e-commerce
something here.
platform
There's
decides what customer data to
1
collect.
minute, Kinjan.
Kinjal, 1 minute. Ibrahim wants to share something.
Yeah.
Can you go to the previous slide one sec? So, as Kinjal explained what data fiduciaries are, any organization that is collecting the data and deciding what are you going to do with the data is considered data fiduciary. Now, there's another class of data fiduciaries, which is called significant data fiduciaries. Now, these organizations who are deemed by the Data Protection Board, who will be considered significant data fiduciary, will have a much higher compliance burden compared to a data fiduciary. Now, who will be data fiduciary is going to be notified by the DPDP board, and that's going to happen soon. But I'll just, from the couple of roundtable conferences that we had been to as part of Data Security Council of India and ASCOM, is that large volume of data, definitely, if organization is processing, and also if it's sensitive, though the DPDP doesn't talk about sensitive health data, but if like your health records, right? If they get breached, it can cause like real, you can really get a lot of distress to the data principle. So these organizations will be considered significant data fiduciary. Now, significant data fiduciary needs to hire a data protection officer, who is one of the new roles that all these organizations will need to hire. They will talk to the regulator, customers, and also manage the program internally within the organization. That's the first thing, have a DPO on board. Second thing is they have to appoint an independent auditor and go through DPIAs, data protection impact assessment, right? And the organization also has to appoint an independent auditor first and do audit on them, and they have to give the report on the annual basis, especially for data protection impact assessment, right? That's high risk processing activities. So most of insurance companies, banking would come under, significant data fiduciary. Now, one more thing on a significant data fiduciary is that if they're using any kind of AI algorithms, right, they will basically need to make sure that they are able to be so transparent that they can exhibit to the regulator that, that all the AI principles are met. There are no biases, there are no hallucinations. If you ask a question today versus tomorrow, it should be similar, right? So, I mean, it has to go through a data protection impact assessment to make sure that the AI algorithm, the significant data fiduciary is using, is not causing harms to the freedom and rights of a data principal, right, which is customer or a employee. So I just wanted to add that part because those significant data fiduciaries have much higher compliance burden than a data fiduciary.
Yeah,
Thank you.
I have
Ibrahim,
covered
Ib-
significant data fiduciaries later
Okay.
on in the
Ibrahim, if
presentation.
I understand correctly, there's various health companies and insurance companies and hospitals, all other people broadly who are collecting the health related information will come under this category. Am I correct?
Yes, I mean this is going to be the master umbrella, and all like your healthcare, your IRDA, or your RBI, SEBI, all the regulators are going to come with more further detailing to this. But this has set the umbrella, right, for everything.
With certain examples, an e-commerce platform that decides what customer data to collect and how to use it becomes a data fiduciary. A bank that determines processing of KYC, transaction, and credit data becomes a data fiduciary. Hospital, when it comes to patient data collected and stored, becomes a data fiduciary. Social media platform, profiling, content delivery, advertising, etc., becomes a data fiduciary. Government department that determines data processing for welfare schemes become a data fiduciary. Employer, now again, employer, so that covers a lot of organizations, determines that determines employee data collection and usage becomes a fiduciary. Coming to data processor, it's another definition and concept under the act. Data processor means any person who processes personal data on behalf of a data fiduciary. So this particular entity, it does not determine the purpose of processing. The minute you determine the purpose of processing, you become a data fiduciary. But this particular data processor does not determine the purpose of fiduciary. It does not decide the means independently. It acts strictly on instructions of data fiduciary. If an entity starts deciding why data is used, it stops being a processor and becomes a data fiduciary or a joint fiduciary.
That means all
Some examples.
Kinjal, that means all the practicing people like a Meta and Meta firm or practicing company secretaries, practicing chartered accountant, practicing cost accountants, all those people who are there, who are collecting the data, they are processing for one reason or other, either for the certification or filing and other things and all those things. All those people will get covered on this.
Yes, they're all data
Yeah, and
fiduciaries.
this is a very, very interesting topic, and this is one of the things that organizations should start working on this immediately. I'm talking from a ground implementation perspective. So now think about all the contracts that you have with all the vendors that you're using. You have to basically send, a updated contract to them for them to sign that they will basically abide with all the DPDP rules that are mandated for a processor. Like as some of the things Kinjal mentioned, they will, have the best cybersecurity controls. They will also basically, not do anything else with the data besides the instructions, clear instructions that are documented in the contract. They only do so and so things. If there's a breach, they will notify them immediately and they will invest in cybersecurity controls. Also, in principle, you are not supposed to send data to an organization that has less cybersecurity controls than you, which is less secured than you. So that's a tricky part. One of the part, which is the most tedious part of DPDP Act is basically doing a data inventory, knowing where the data is within your whole organization, right? But the tougher part is like even you have to map what kind of data elements you are sharing with each vendor has to be documented. Now, can you imagine an organization, how many vendors do they have and what kind of data are they sharing with each of the vendors? That has to be documented, right? And all the all the agreements have to be updated with a very clear distinction who the controller is and who the processor is. That's the biggest problem, right? Because in the vendor agreements, they don't have an ownership or accountability of who the controller will be and who the processor will be.
Right. Coming to certain examples when it comes to data processors. So there is a company who's using AWS to services to host customer data. then the data processor in this particular scenario becomes AWS. Bank who outsources KYC verification, the KYC vendor will become the data processor. E-commerce platform uses payment gateway. Now, any information data that they share with the payment gateway and that they process, they are the data processor, the payment gateway. Employer that uses an HR SaaS tool, where the HR software provider becomes your data processor, employer is the data fiduciary. Hospital that uses cloud-based EMR system, the EMR vendor becomes the data processor, who is strictly acting on the instructions of data fiduciary. Coming to consent manager. Consent manager is again another definition under this act. Consent manager means a person who is registered with the board to enable data principal to give, manage, review, and withdraw her consent through an accessible, transparent, and interoperable platform. Okay, so let's go through this one by one. A consent manager must be registered with the board that is formed under this act. And they provide a single point of access to manage consent for the data principal. It does not represent data fiduciaries. It does not use personal data for its own purpose. It acts solely to execute the will of data principal. It acts solely to give, manage, review, and withdraw consent of the data principal through a platform that they provide that is accessible, transparent, and interoperable. Now, like we saw that, today when you're signing up for something, you have pages and pages of terms and condition with a lot of legal jargon, etc. You really are not reading most of it. You don't know what consent you're giving, what you're reviewing, etc. How much information they are taking from you. This leads to fatigue when it comes to any data principle that is providing consent with regards to his or her data. So this consent manager is essentially put in place to help manage these kind of consents and make it easier for data principal to manage the consent that they're providing when it comes to their personal data.
I'll just
Let's look
add
at certain
something.
examples.
Yeah. Yes, Abraham.
I'll just add something here about consent manager. If you can go to the previous slide. So consent manager is very unique concept in India. If you drop, initially we said that DPDP Act has been modeled by GDPR, but India has used this consent manager as a very unique concept, right? Because mostly if you want to process data of a customer, you need explicit consent from them, just in time, no legal jargon, and explicit. If for GDPR and other global regulations, if you're executing a contract with your customer, then you don't need explicit consent. At some time, you have concept of deemed consent. But in India, there is, you need explicit consent for each and every purpose for which you're processing their personal data, right? For example, if a person opens an account in HDFC Bank, earlier they would basically share it with, HDFC life insurance with their sister companies. But now they have to explicitly say that, I allow them to send marketing emails, and then they need to honor that, right? They need to store that consent. There's a whole framework that's come from MITI of how this consent manager should look like also, right? And they need to, it has to be immutable, so it can be used in court of law. And it's a very unique concept. So other global company, the whole idea is that they want to make it kind of a UPI kind of a system, and also in a way that that'll replicate the account aggregator framework, if you guys are familiar with that. But that's only for the financial services. But this will be, the consent manager will be a very similar concept in the non-FS sector as well. Yeah, so consent management is the first deadline that's coming up in November, and this will mean consent management from your website also, website cookies. You will see very soon. You will see a pop-up banner from all websites that are keeping trackers and cookies on your browsers.
Yeah. Ibrahim, I have one small question. So I don't know whether I am correct or not. Now, what happens when you are talking about the explicit consent?
Hmm.
Today, whenever we execute some loan, etc., there are agreements which are printed in such a way, I will rather put it in a very absolute terms. It all printed in the fine print, not to be read. And if we blindly sign,
So
because unless we sign, we are not going to get our whatever we wanted. So we are forced to sign, rather, I would put it that way. Because either you don't have the choice to alter it. You have a choice either to consent or not to consent. If you not to consent, you don't get what you want. But if you consent, you'll have it. But the thing is, without understanding, without reading, because it's all in the fine print, it is, I think, probably it is written that it should not be read. That is the way it is there. How that will change in this act? That is the
I think the
question I have.
intention, right? A very good question, very, very good question, relevant question, Professor Bala. And I think the intent of this government is that basically they want to make privacy awareness to everybody in the society, right? So that's why very soon you will see data privacy policies being sent to you by all the organizations that you have shared personal data with. They will need to share the privacy policy in 22 regional languages, right? Again, this is a very unique concept in India that they want every like a third tier city.
Automatically keep clicking without understanding what are the intricacies, what are the things, etc. Another thing.
But that's why the law very clearly says that it cannot be legalese. It cannot be like legal jargon. It should be easy to understand. Normal person that can understand. Just in time, one sentence. So in fact, one of our insurance customers, this is the problem, and we are like breaking it down for them. The huge paragraphs that they have where people write just such a big paragraph where they take multiple consents at the same time is not allowed anymore. So even if you go to an insurance company's website, they will take consent if they have a call me back form or everything. They very clearly they will ask you that we will take this data just to contact you for this purpose. So you will see that in most of the websites now going around. But
Yeah.
it is very intrusive, right? That some of the cookies and that our clients basically store on their customers' browsers is so intrusive that they actually, when you're shopping or you're transacting on a bank or you're buying something from Amazon, which they have no reason to know, but they exactly know. They're building a persona from you. Okay, this person shops in the night, he's impulsive, he likes sweet, something, and then they will personalize stuff for you. So
yeah, that is what it's seen in many of the sites. Although we think we have visited only this site, we get various, unwanted calls, etc., from the other sites. By using this particular site, that means automatically the information travels down to various other places without our knowing it. That's what it happens today.
Right. So this concept of consent manager will become applicable from November 2026. It's not applicable yet. So we have looked at different definitions and different, say, characters
can I just
under
add one
this.
thing? I'm sorry, Kinjal. Can I just add one thing to the? I think it's pretty important, right? That if you go to the previous slide, so the deadline is about May for consent manager. Sorry, November 2026 for consent manager, and in that much time, what organizations are expected to do is they are supposed to basically reach out to all the data principals, which is their customers, and tell them that this is we have updated our privacy policy. This is how we are using your data. This is who we are sharing the data with. And if you wish, and this is the kind of consent we have from you, you can unconsent if you like. You have to give that option to them. Now, can you imagine the exercise that organizations basically need to do? I mean, the question, Professor Bala, that you picked up about insurance company and the legacy data from legacy customers who are there in legacy systems, you have to send each and every customer SMS, email, WhatsApp, message, whatever communication you're taking. But you need to send them updated privacy policies and give them the option of opting out if they don't want further processing of their data. That's a huge ask until November 26,
So now we looked at different parties and different characters under this DPDP ecosystem. One is the data principal, who is the person to whom the personal data relates. Data fiduciary, who's collecting the data, deciding how the data is processed. Data processor, who's processing the data on the instructions of data fiduciary. Consent manager, who's managing consents for the data principal. Significant data fiduciary, which we will discuss in more in detail later, then data auditor who is auditing these different systems and policies and management of this personal data under this act. Then the Data Protection Board of India, which is in the process of being appointed today, who is essentially a regulator for this DPDP Act. Now, under the DPDP Act, these different
Kinjal, go to the earlier slide now.
I just realized there are a lot of questions here as well.
Yeah, we have to attend at the end, otherwise we will not be able to finish. That's the reason. So that's why you keep on adding your comment at the end, we will cover that. And many times they ask the information which is there in subsequent slide.
Okay.
Just quickly, you can just mention that what it is, role of this. That will clarify the audience. Kinjal, you have explained this, but I'm requesting panelists to just explain this with the practical example if possible.
So data principal is anybody who will whose
Right.
data is being collected, right? I mean, I think she already mentioned
Yeah.
that it can be employee or customer, data fiduciary or significant data fiduciary, anyone who's collecting the data and deciding on the means and purpose of the data. But now suppose there's somebody as Bank Bazaar, right? Bank Bazaar basically collects the data, but it doesn't collect, it collects it for multiple people, right? So it becomes in certain way a joint controller also, right? Because if they are collecting only for purpose of a single client, the agent is collecting data from individuals only for a single client, then they become joint data fiduciary. So they have joint responsibility as per the law. Data processor we've already covered. I think she's given good examples like TCS and all these companies. Whoever you send the data out to. Most of the people say that they don't give data to any data processor, including one of the stock exchanges in India. But then we had a long discussion that if you're using Office 365, you are sending data outside. All your data, all your email is outside, right? So people basically want to just say that they don't have anything and they don't need to comply, right? Couple of days I was on a call with a CISO, and he really deals with information security, protecting the data, but privacy is not there, right? So he's saying, I mask all my data, so that means I don't need to comply. So, I mean, that awareness that it's a completely new stuff and a lot of things are required. So if you are using Office 365, you have a data processor, so you have to make sure.
Interesting, yeah.
Yeah. Consent manager, we have all discussed. This is going to be more clarity is going to be required. Is going to be coming out because we are seeing that a few consent managers are organizations like account aggregators. But what we are seeing, a lot of banks, they are building their own consent management platform themselves. Now, this is again something which was not expected. But a lot of big banks, of the likes of Yes Bank, they are, or PayU, which owns LazyPay. Those organizations are building their own consent because they don't want to expose their whole technology stack to a third-party vendor. Because for whatever reasons, right? So these people are building their own this thing, but then the accountability and transparency, right? If something goes to court, then how can you? The whole idea is that an independent consent manager is completely independent without any biases. If you are storing your consent, then it doesn't have that
independence.
Yeah, independence. Data auditor. This is a new. I think most of the. This will be a whole new breed of auditors that will be required. Right now, I think EY just released a report day for yesterday that only out of the professionals who are there in the data privacy, only 30% feel really competent, and about 60-70% are not feeling what is going to be required from them from DPDP. So a lot of upskilling, skilling is required, right? Data Protection Board comes under the MITI, and they are the ones who are going to be putting the fines.
Yeah, thanks. This given the entire activists who are there in the system of DPDP. Thanks. Yeah, Kinjal, go ahead.
Yes. So under this act, this act puts a lot of responsibilities and rights on all of these different parties. So one of the main parties on whom a lot of obligation and responsibility has been put, because this is the person who is deciding how the data is processed, where it is used, how it is used, being the data fiduciary. Let's look at all the basic core obligations and responsibilities of a data fiduciary. Now, data fiduciary is the one that is collecting the data and deciding where, how the data is being used. So, one of the main requirements for a data fiduciary is that they can whom this data relates. The consent must be free, specific, informed, unambiguous, unconditional, and given through a clear affirmative action. It cannot be ambiguous. And processing without this valid consent will result into illegal processing. Now, there are certain processing of data which falls within legitimate uses, which includes performance of legal obligations under particular act or court requirement, things like that, medical emergency, government functions that have been authorized by law, employment-related purposes, when it comes to safety at work, etc. Where using this data without consent is allowed under the law unless it is specifically forbidden by law. Then that is allowed.
As you can see on the right, there are very slim things, right? Medical emergency, like if somebody meets with an accident, you don't really need to like give his name, number. You need to basically admit him first, and then you can, no consent is required from this thing. State functions, if somebody is basically, a narco terrorist or something, right? Then they want to do surveillance on him. But that also has to have certain bases. Very slim things over here, right? Employment, because sometimes as a when you're applying for a job, you are voluntarily sending your resume to the organization, right? So though you don't need their consent when somebody is applying for a job. So what I'm trying to say is that the certain legitimate uses for the data is very slim. For everything else, be prepared. Organizations be prepared to collect consent, explicit consent, and record those consents on blockchain ledger and honor those. If somebody says that do not send me marketing emails, you cannot send them marketing emails. There are huge fines associated with consent.
So that means in this particular act, the implicit consent will not be working.
That's gone. That's gone. Implicit consent is
the
word itself is actually doesn't mean deemed consent. No. Implicit or deemed consent that used to call in GDPR. That thing is not really.
No, why I'm asking this question is, many times we share the financial details to the practicing people only for the purpose of filing and things, etc., and other thing and all. So when we are given this for their usage for this particular purpose, the financials are with him. They can use for some other purposes also for which I have not given the consent. Because the whole idea is you have shared the information to me, I am using it. So there is already an implicit consent is there. Can that work actually? Yeah, because Meta, if they are doing some sort of the filing for the people, the financial information is shared with them. It is shared only with them for the purpose of filing and other things, etc. But can they be used for any other purposes for which is a specific consent has not been taken? Because you already passed on the information to me, you have given the consent to me for your use.
Yeah, then that broader, purpose as part of your agreement can be defined as a consent, right, for all business-related processing activities, right? But that will be you will still need to take explicit consent in the beginning at a larger umbrella level, I believe. I'm just need to understand the nuance a little bit more.
That means organization has to got a lot of things to think and reword their agreements and other things and all, how to pass the information, where it can be used, where it cannot be used, to do's and don'ts and all those things. That's a big job. Yes, Kinjal.
Kinjal, have you covered children consent?
Yes.
Yeah, it is coming. It is coming.
Coming to the second requirement, again, which is notice and transparency obligations. So before or at the time of collection of the data fiduciary must provide a clear, accessible notice stating type of personal data collected, purpose of processing, rights of the data principal, manner to withdraw consent, grievance redressal mechanism, if they have any grievances, details of data protection officer, if that is applicable. So if it's a significant data fiduciary, which is a concept we'll be looking into in detail later, then they'll have a data protection officer. That is one point of contact. If those the details for the such data protection officer must be provided in the notice at the time or before the collection of data. This notice must be clear and plain and must be available in English and other Indian languages. I think there are 22 Indian languages mentioned in the age schedule, and there should be no dark patterns or deceptive interfaces while taking this consent. And in case of any dispute, the burden of proof lies on the data fiduciary to prove that valid notice was given and consent was obtained when it came to collection of data. Hello?
Yeah, go ahead.
Yeah. Yes, go ahead.
Yes.
Your voice is clear.
Okay. Coming to data processor. Now, a data processor becomes a vendor for a data fiduciary who processes data on behalf of the data fiduciary. So, a data fiduciary may only engage a data processor under a valid contract. The fiduciary remains responsible for the processor's compliance. So, again, the ultimate responsibility when it comes to management of personal data, it always stays with the data fiduciary, even though it may engage various vendors with whom this data is shared, but the ultimate responsibility will always stay with the fiduciary. So it's the fiduciary's responsibility to ensure that proper practices when it comes to data protection is maintained at these vendors' ends. Coming to data integrity. So the data fiduciary must ensure that personal data is accurate and up to date. It must enable correction and updating upon request. It must avoid decision making based on outdated or incorrect data. So, if the data is used for decision making or shared with other fiduciaries, it is the fiduciary's responsibility to ensure its completeness, accuracy, and consistency. Then, coming to grievance redressal, it is the fiduciary's responsibility to establish an effective grievance redressal mechanism, acknowledge and resolve complaints within prescribed timelines, which is 90 days as of right now, and provide escalation to data protection board if such grievances are unresolved. We'll look at the grievance redressal mechanism a little more in detail later. Coming to data retention and duty to erase. A data fiduciary must retain personal data only as long as necessary. They must delete data once purpose is fulfilled and retention is no longer legally required. This creates a mandatory data lifestyle obligation and not an optional housekeeping process when it comes to data retention and management. In case the consent is withdrawn and the specified purpose for which the data was collected is no longer there, then the data must be erased. For larger e-commerce, social media, or gaming entities, purpose is deemed finish if the principal does not contact the fiduciary for 3 years. Then they must delete this data, the personal data, when it comes to the data principals that they're dealing with. Fiduciaries must inform the principal at least 48 hours before this scheduled erasure. Now, there is security safeguards. So, data fiduciaries must implement technical safeguards, that is, encryption, obfuscation, masking, strict access control when it comes to the data that they are managing. There must also be organizational safeguard, which is your different policies, trainings that must be put in place. Then the measures that are taken to ensure security safeguards must be proportionate to the volume of data that is being handled, the sensitivity of data, risk of harm, etc. Reasonable security practices is now a statutory obligation for this data fiduciary who's collecting this data and not a best practice. It is mandatory in nature. They are required to maintain logs of data access and retain these logs for 1 year to enable any kind of investigation that takes place later.
Just one,
There is a breach.
Yeah, Kijal, 1
Yeah.
minute. Ibrahim wants to add something.
so what I mean, these security safeguards, that these, some of the mandatory ones they have named as examples or exhibits, but there, the regulator is going to see the intent and how are you going, if and this has the highest fine, right? If an organization does not put enough security safeguard controls, it has the maximum amount of fine. If they need to see an intent that the organization is investing based on how much ever they deem fit as per the operations processing operations. But the only way to show the regulator is through some kind of certification that you have done. There's no other way of basically exhibiting, right? Because these are few of them, but there are many more. DSTM technology, anonymization, pseudonymization. There's a lot of other technologies, and that's why certification is very good for organizations to keep to show that they have the industry-wise best standards, right? Like a ISO, NIST, and what have you.
Yeah. And the burden of proof to prove that lies with the fiduciary, with the audit trails that they maintain when it comes to this.
And as I don't know if I was very clear when I said that the fiduciary has to make sure that the processor has great cybersecurity control. So not only just asking them, but basically more comprehensive the cybersecurity controls, like what we do for some of our clients right now, is asking them to attach evidence also that do you have a privacy framework? Do you have a good exit policy? There's a whole framework for vendor risk assessment where no, I mean, this especially cybersecurity works on zero trust. So you basically need to see evidences that organizations have actually applied these safeguard controls, to the level of sometimes they randomly select, like they want to see an antivirus being deployed, DLP, data loss prevention, which is a very big part of DPDP Act, right? Nobody should be able to just like take data from a USB cable. They want to see it implemented and they ask for screenshots.
So you can say to avoid liability, regulatory liability in future, the fiduciary has to take care very clearly with the proper proof that that processor has all the security, right?
Yeah,
Yeah.
but you as a large organization which has a matured cybersecurity controls, you cannot give it to any Mickey Mouse company. You have to basically make sure that other companies that you're sharing data with at least has standards that are your level, not
Okay.
lower than you. You're not supposed to send data to any organization that's has lesser cybersecurity controls than you. So I
Now,
think the most matured in that is basically the BFSI, and from BFSI also I'll say the banking and fintechs are more matured in that, but every
Right.
other function is really lagging behind in that area.
Yeah, we have that clients and they ask so many information with the proofs for our the security system. Actually, they have that in place. You are right. Thank you.
Yeah, because there's a master RBI regulation also that they need to comply with that, which has a lot of checks and balances for third party.
now the act specifies a breach response protocol. Now, this didn't exist before. In case there was any data breach that happened, there was no sense of accountability, and this happened very often, which led to a lot of leakage of data, misuse of data, etc. So this act actually codifies a protocol for when such a breach happens. So when so what does a personal data breach mean? It means that any unauthorized processing of personal data or accidental disclosure, acquisition, sharing, use, alteration, destruction, or loss of access to personal data that compromises the confidentiality, integrity, or availability of personal data. In case of personal data breach, the data fiduciary must notify the Data Protection Board of India. It must also inform the affected data principals whose data has been breached, and it must do notified. So when it comes to the board, a detailed report must be submitted within 72 hours. This will include broad facts relating to this breach, measures implemented or proposed to mitigate risk, any findings regarding the person who must have done it, remedial measures to prevent reoccurrence, etc. Again, when it comes to the data principle, data lakes, disclose nature, extent, and timing of the data breach, consequences that might lead because of such data lead when it comes to this data principle, measures implemented, safety measures that the data principle can take to protect their interest, etc. Now, I
I'll
think
just
we've alluded
I'll
to
just
this.
quickly add something for the breach one. If an incident really happens, then that still needs to be reported to the CERT, which has a 6-hour deadline, right? Which is more for cybersecurity. If there's a cybersecurity incident, you still have to report it um, to the certain regulator within 6 hours. And what constitutes of a incident into a personal data breach, right? So I'll take an example of employee laptop being stolen. Simple example: an employee laptop being stolen, and that employee laptop basically had encryption in it. So even if a third party stole it, it doesn't have the encryption keys. They will not be able to uh, decrypt it, right? In the ideal world, but as part of that investigation, when the data protection officer usually will run the investigation, they will need to see what data was compromised. They need to run a whole investigation report, right? Investigation template, and then he needs to take a call that why is he not reporting it to the regulator if he decides not to report it to the regulator and to the customers, because the hard drive was encrypted, and that's the rationale that he took, right? To not inform the customers. Moving a step ahead, right? The law also, I mean, if data basically, what is a personal data breach? Personal data breach could also mean data that is shared from one department to another department accidentally. If the employee, all the employee related data has been, sent by email to somebody from the marketing team, that is also considered a data breach. At those time, also investigation templates needs to be run, and whatever decision needs to be taken, right? Um, and I'll take a small example for data breach in general. If anybody who's ordered pizza in Domino's in India, their data has been compromised. It's out there. Your name and your phone number is already out there. But nobody actually went and even nobody, updated the customers so they could do some grievances. They could change their passwords on other portals as well, because there's a lot of linking to all these things, right? But with this new law now, within 72 hours, you need to, you know, uh, report it to the regulator and to the customers, uh, so they can basically change their passwords or what have you, right? So the just wanted to say that the whole definition of incident and breach is pretty large.
Yeah, as you rightly say, I recollect this, not today, maybe some 25 years back or something. If you have the bank ATM card, if something goes wrong, there will be a telephonic check. You give your name and address, give your date of birth, and you also tell me your phone number or something like that. Then with that, they will give you the new password. They will send it actually. So people used to make a scam out of that, and they used to do it. Has happened. It has been reported in the newspaper. Later on, they changed many things actually as we moved along. That can be done actually. Even today also it is possible in some of the cases, as you rightly said.
Towards the end of this webinar, I'll put one website. It's called Am I Pond, right? So you can put your email address, and you guys will see all the places which your data has actually got breached, right? So even LinkedIn, if you've used LinkedIn at a certain point of time, your data has got breached. Some like Pepperfry, a lot of companies will come up if you've been using House. So I'll put it later towards the chat. It's just a fun exercise that you guys can see that how many times your data has actually got breached.
No, I actually agree with you, because many a time what happens whenever we do the things, a lot of pop-up things which keeps on coming automatically. How they get to your email ID, how they get your what number, etc. Another thing and all, because it is data is being shared by somebody unwantedly without your knowledge. That is why it is happening today.
Moving on. So there are special protection given under the Act to say children and person with disabilities. Where data principle is below the years of 18 years, they must obtain a verifiable parental consent, that and they no company, no fiduciary is allowed to do any kind of behavioral tracking, targeted advertising. Neither they are allowed to process that is likely to cause harm to these children under the act. This this so this kind of protection is one of the strictest one that is there globally when it comes to data protection for children.
That's a
Coming
very, very
to
difficult. That's a very, very difficult ask, right? Taking parental consent. So how to implement it and how to assess it is very, very difficult, right? Because tomorrow, if your child might, there are a couple of ways of basically getting a parental consent. Maybe through integration with DigiLocker, right? Um, or taking the parent's credit card to basically verify that they are above 18, right? So these are additional technology implementations that organizations need to do, right? Right now, it looks like it that DigiLocker will be the most conducive way of doing it, getting parental consent. But sometimes there's also a question that sometimes you're taking more data to become for the subject of data privacy, right? So
coming to significant data fiduciaries, now these fiduciaries are notified by the government. So these are fiduciaries that they have special features. They are large in the kind of data they handle. So when it comes to volume and sensitivity of personal data, it's very high when it comes to them. Then they deal with personal data that has risk to rights of the data principle. Then they might be dealing in data which has risk to sovereignty and integrity of India, or even the electoral democracy of India, or even the security of state. So when any kind of fiduciaries that are dealing with this kind of data, they may be notified as significant data fiduciaries by the government. And they have a higher level of obligation and requirement under this act. And they may also face restrictions on transferring data outside of India if the government decides so. Now, these additional compliances under the Act refer to appointment of India-based data protection officer, and this person must directly report to board of directors. It is one single point of contact for grievance redressal, etc. When it comes to various data principles that the data deals in, then they must have an independent data. They must have independent data audits that must be conducted on notified frequencies by an independent auditor to evaluate compliance with this particular act. Uh, they they also have data protection impact assessments that they must conduct, and publish these reports. And they must have enhanced security and governance controls. Um, and they may designation they're not allowed to designate any of these kind of duties outside of their organization.
So just a DPO, the subject of a DPO is very interesting when it comes to India. The DPO is supposed to be an independent role. As rightly mentioned, either like highest management, board of directors, or independent function. So globally, if you take any data protection regulation, this is an independent function. They should not have a dual role while doing a data protection officer, right? But the Indian law does not basically talk about any of this. So in my experience, I deal with data protection officers who are completely legal people because they are drafting policies. Obviously, IT is involved. Information security officers are wearing that global dual role because they actually know how the data is being there in the organization. One of my insurance company actually a company secretary and the legal head is the DPO. Though not very technical, but then she has a very technical junior DPO, pseudo DPO who's working under her, but the responsibility is lying within her. At one time, the CTO and the legal head are they basically pushing the responsibility. So in India, what I'm trying to say is very unique again compared to the rest of the world, that a person can have dual roles. Till now, maybe in a further notification, it might come that it has to be a completely independent role. But right now, in India, we are seeing, uh, dual roles like legal head with compliance head or CISO or CTO. Just wanted to add that, right?
Yeah.
Right.
Maybe initially, as you rightly mentioned, as the time passes, they will make it independent.
Yeah, as you really say,
Yeah.
as we go by implementation, then things will come up accordingly. Things will also automatically change.
But
Yeah.
lot of like top, very like I would say the top 20, 10, 20 CISOs of India very proudly they wear the badge of CISO and DPO. And the only
Now,
reason is because they really know how the data is flowing in the whole ecosystem from a technical perspective, right? So, but the best DPO,
right.
in my opinion, is somebody who has you know all the knowledge, little bit of every knowledge, technical knowledge, legal knowledge, chartered accountant who understands audit, ISACA, IT controls, everything. And most importantly, that person should be the most successful DPOs that I've seen who've done a great job is uh, a people's person, because you have to talk to the regulator, you have to be the seller of data privacy within the organization. So you are the face, right? Promoting data privacy within the organization and also dealing with customers. So people, and again, other stakeholders like IT or legal cuts across many functions. So people person having broad knowledge right now in India seems a very great fit.
Coming to the data principle, the Act codifies the rights and responsibilities of a data principle. Let's look at what those are. So when it comes to rights, all data principals to whom this personal data relates have the right to access information that the fiduciary has on them. They also have the right to correct and update the information that with the fiduciaries when it comes to their personal data in case there is a change in phone number, address, etc. Then they have a right to erasure. If they don't want their personal data to be with a particular fiduciary to be processed in a certain way, then they have a right to ask them to erase their personal data. They have a right to grievance redressal. So, under the Act, the fiduciary is required to have an internal grievance redressal mechanism. If that fails, then there is an external grievance redressal mechanism under the code. We look into that in the coming slides. They also have the right to nominate someone when it comes to practicing all of these rights that they have under the Act. They also have the right to withdraw consent when it comes to their data that is being used by fiduciaries. Now, there are certain duties also that have been codified under the Act when it comes to data principles. So they must comply with all applicable laws while exercising their rights under this act. They cannot be, not complying with other laws when it comes to this particular act. They should not be impersonating someone else while providing data. They must not be suppressing material information for when it especially when it comes to state issued data collection, etc. They must furnish only verifiable authentic information, and as and when required requesting correction and erasure when it comes to their personal data. So, so under the Act, a lot of rights and responsibilities have been placed on data principals also when it comes to their own data. Coming to consent managers and their obligations and duties under the code. So coming to requirement when it comes to a consent manager must be registered with the Data Protection Board of India. It must have um, financial solvency and a net worth of more than 2 crore rupees. Management must be sound and possess specific reputation of fairness and integrity, and it must possess sufficient technical capacity to fulfill obligations prior to registration. In the sense, they should have the capacity to put in place processes, systems, cybersecurity processes, and controls that allows them to carry out the function required under the Act. Then coming to core, so when it comes to consent managers, they must provide an effective mechanism to enable granting of consent uh, to one or more fiduciaries. They must enable withdrawal notification or denial of consent with ease, and ensure that this consent is free, specific, informed, unambiguous, and granular. They must also have data blindness, which means that consent managers must ensure that they do not access, read, or use the personal data flowing through their systems. They must be blind to this particular data that is flowing through the system. Their role is limited only to consent signaling and not data processing. Technical architecture ensures end to end encryption or equivalent safeguards. And they should not become shadow data processors. So this is a very important requirement under the Act, and this consent managers must keep these processes and systems that they have maintained in writing and maintain audit trail when it comes to these requirements under the Act, because this is paramount when it comes to their role under the Act. Then they must maintain record and retain it. So consent managers must maintain complete records of consents granted, consents withdrawn, consents denied, and notices issued by data fiduciaries. And these records must be maintained for 7 years or as prescribed. And all this must be auditable and traceable under this particular act. Now, they must maintain data transparency and access to records. So, upon request, consent managers must provide data principals access to their consent records, and they must ensure that the records are machine readable, easily downloadable, and accurate and complete. Then, coming to certain requirements when it comes to accountability and conflict of interest. Consent managers must act in fiduciary capacity and prioritize best interests of data principals. They must avoid design choices that nudge or manipulate consent outcomes. And they must also are not allowed to subcontract or assign any of these legal obligations under the Act to any other party. They cannot outsource or delegate their statutory obligations and must retain full legal responsibility for compliance. They must also avoid conflict of interest. So, consent managers must actively avoid conflict of interest, which includes no financial interest in data fiduciaries, no overlapping directors, KMPs, or controlling shareholders, no employment or consultancy relationships that impair their neutrality, and there's a mandatory disclosure requirement when it comes to promoters, directors, and shareholders holding more than 2% equity in any of the fiduciaries or any of these consent managers when it comes to um, uh, clash of conflict of interest. Then consent managers must implement robust technical organizational safeguards to ensure integrity of consent records, availability, confidentiality, etc. There must be internal and external audit mechanism. So consent manager must establish effective audit mechanism and periodically review technical control, security safeguards, compliance with neutrality principles, and they must submit these audit outcomes to the data protection board. And in case of breach, there are several penalties that are applicable by the data protection board, which we'll get into later. Now, coming to the Data Protection Board of India. Now, the Data Protection Board of India is again the sections relating to that and rules relating to that are already implemented, and it consists of chairperson and elected members. They can and they have the power of a civil court. They can summon, inspect data books, etc. They can impose penalties under the act on all these different parties under the DPDP ecosystem. It is essentially an enforcer of the DPDP Act and rules. Any kind of inquiry that it takes, when it comes to data protection, it must try and conclude within 6 months. Um, and so yeah, it does play an important role when it comes to the DPDP Act and its rules. We will get more and more clarity on its functions and how it functions, etc. Once there are more sections and the DPDP Act has come into effect in on a larger scale. Now, the DPDP Act puts in place a dispute resolution mechanism, which starts with the data fiduciary. So, under the Act, the data fiduciary mandatorily is required and obligated to establish an effective mechanism to redress grievances of data principals. And the data principal has a right under the Act to have a readily available grievance redressal mechanism when it comes to a data fiduciary and consent manager for any kind of omission or any kind of grievances that they have. Then the fiduciaries um, must communicate the manner in which the data principal may make a complaint to the data protection board in the initial notice when they are collecting data, and they must also give information on this particular grievance redressal mechanism. Then fiduciaries must prominently publish the business contact information of the data protection officer in case of a significant fiduciary for a person authorized to answer questions about data processing on their website or app. And this information must also be included in every response to data principals communication. A data fiduciary or consent manager must respond to the grievances within a period of 90 days. And they are required to implement appropriate technical and organizational measures to ensure that they have systems that is able to respond within this 90 days. Um, a data principal is required to exhaust the opportunity first provided by the data fiduciary to resolve this grievance. And if they are not able to do so, then they can approach the data protection board. If the data protection board believes that the complaint can be resolved through mediation, then it may direct parties to attempt resolution where mutually agreed upon a mediator. Then, in case any complaints are received by the board, then the board has the power to inquire into these complaints regarding breaches by fiduciaries or consent managers and can impose penalties. And it functions as a digital office, meaning that all of these functions that are codified for this data protection board can be done online itself as a digital office, meaning the receipt, allocation, and hearing of complaints uh, are digital by design. Then there should be no false complaints. Data principals have duty not to register for false or frivolous grievances. Then if the board thinks that the complaint is false or frivolous, it can put out a warning or impose a penalty. Data principals can also appeal by any kind of order. Actually, any person aggrieved by the order of the data protection board can appeal with the appellate tribunal within 60 days of the order. Now, penalties has been the most eye-opening part of this data protection law because these are humongous when it comes to any kind of breaches that take place. So, under this act, there is no imprisonment as such that has been provided, but the financial penalties that are being put on the uh, people who are not complying under this act is quite large. So, in case of failure to take reasonable security safeguards to prevent breach, this is with response to anyone handling personal data under the DPDP Act. If they fail to put in place reasonable security safeguards, which we mentioned earlier when it comes to um, um, cyber security or obfuscation or things like that, and putting in place systems and processes, um, uh, encryption, etc. That um, is up to that can be called reasonable security safeguards. Um, if they fail to do so, then there is a penalty of up to 250 crores. Then, when it comes to failure to notify board or user when there is a breach of data, then there is a penalty of up to 200 crores. Then, when it comes to breach of children's data obligation, then the penalty goes up to 200 crores. And in case of breach of significant data fiduciary obligations, then the penalty goes up to 150 crores. Now, if if a data principal fails to perform the legal duties, now we're talking about the data principal, the person to whom the data belongs. If they fail to perform their duties, such as if they are impersonating someone else, filing frivolous complaints, they may also be fined up to 10,000 rupees. Then, breach of any other provision under the Act or its rules can lead to a penalty of up to 50 crores rupees. So, any other breach apart from any of this can lead to a penalty of 50 crore rupees. Then, the board does not automatically apply the maximum fine. Instead, it must consider several factors to determine the proportionate and effective amount. So they will consider nature, gravity, and duration of the breach. They will also take into account time and sensitivity of personal data that is being affected, whether the breach is repetitive in nature, and if any financial gain realized or loss avoided as a result of the breach. It will also look at the mitigation efforts taken by the person and how timely effective those actions were. And they will also look at the overall impact on the person and the need to secure future observance of law. So if they think they need to make an example, when it comes to handling of data, then you might just get a maximum fine. So, considering all of these different criterias, the Data Protection Board can levy penalties when it comes to different fiduciaries. Then there is one more, consequence for a repeat violator. So the Act introduces a blocking mechanism for repeat offenders. So if a data fiduciary has been penalized by the board in 2 or more instances, then the board may advise central government to block public access to information that enables that fiduciary to offer goods and services in India. So, in case there are repeated multiple breaches and instances of non-compliance under the Act, then the board can directly ask and block public access to information that allows them to offer goods and services in India. It'll give the fiduciary an opportunity of being heard, and if still it's not convinced, then they'll block access to fiduciary's platform in the interest of general public. So, coming to our compliance roadmap and the way forward when it comes to the DPDP Act in India and the concept of data protection in India, and how companies can go about adapting to various requirements under the Act. So, under the Act, it is essential that a DPDP governance structure is firstly established, and embed data protection into corporate governance practices and not IT operations alone. It must identify roles of a data fiduciary, data processor, significant data fiduciary, etc., wherever applicable, um, and codify it in various policies, of the organization. They could constitute a DPDP compliance steering committee, with having different functional heads such as legal compliance, IT, cybersecurity, HR, product operation, risk, internal audit, etc. That helps the company kind of come up with a framework on how they can comply with this particular act. It can it
Ibrahim,
must
Ibrahim, Coming to this compliance roadmap, everything is fine, but before all those things, don't interface with all the departments in the company, including the top person of the company, chairman, director, other directors, etc., and other things and all. Since you are in the field, have you conducted any sort of the awareness program, bringing to the notice with the interface with the different department people, etc.?
Yes, absolutely. So basically, the first step that we do is that the data protection officer, he's only there to operationalize the program. So the first step that we always do is that we have the CISO make a data governance committee, right? And data governance committee will have people from all different departments, and obviously ultimately they'll be responsible. The chief human resource officer or the chief financial officer, HR chief HR officer, they will have a privacy champion that they will assign, because the initial one thing that she has written, right? Map the data landscape, create a personal data inventory, which is the utmost right first thing, first blob, right? Map data, personal data. This usually is a very tedious exercise, and process owners themselves will be able to only document that process. The DPO will kind of manage it. So take, for example, what is the new hiring process, right? From a PII perspective. So you will, have to understand the process and document the process, also have related applications that are associated with it. What data have you collected? Has consent been there? It's a very detailed sheet called ROPA, Record of Processing Activities. It's a GDPR term, but each and every element from that is required by our law. So what I'm trying to say is that you need buy-in from each and every department head and the process owner to help complete that thing. So we do that with the help of workshops first.
I won't be surprised tomorrow there will be insurance policy on this for the data protection, etc. compensation.
They already started. Are you talking about cyber insurance?
Not cyber insurance, DPTVA. Any data leakage, etc., another thing and all arising out of it.
DPDP started DPDP insurance by 250 crore is the only driver why organizations want to secure themselves. Otherwise, I don't think the
that is what. By looking at the fees, the 200 crores penalty, I thought immediately there is an insurance company will frame is a suitable insurance policy at the various levels, like a DNO insurance policy. Yeah.
But insurance companies are also doing a DPDP assessment to basically underwrite the policy. So they are also underwriting it deeply. They're doing vulnerability assessment, penetration testing also on these organizations to see how secured they are by hiring third parties. Like
I can see here, there are a lot of scores for the various professionals, starting from insurance companies, practicing professional, even employee people, even interdepartmental phases. Everybody has got a greater role to play in this. That's what it looks like. Not only that, for the practicing people also, there is a very good opportunity for the people, because when it comes to the company secretaries, they have a duty to ensure the compliance under all the applicable laws automatically. That will be one of the things which will be coming. It will be good for the employee and as well as the practicing company secretary. Same thing with the chartered accountant, because when they are doing the auditing, etc., they have the obligation to report the things in the Caro report, etc. They have a greater role to play. Similarly, when it comes to the cost data, again, it's a privacy data maintenance shared. They themselves should become a data processor, and again, they are actually perform themselves, and they let also ensure other things also performed. All those things are there, I think.
I mean,
a lot of things.
Yeah. The Economic Times recently just said that the immediate opportunity in the next 18 months is about 20,000 crores, right? Encompassing everybody. Like, see, there's a pie for everybody. It's a new industry, right? So
correct.
There's a pie. The chartered accountants will come, I think, from next year, where they have to appoint independent auditors. Right now, organizations have nothing. So even when we do gap assessments, it's all basically, implementing the framework. From next year, when the law comes into effect, then the DPIAs, independent auditors, that will come into effect, right?
Again, probably when you're talking about the auditor, again, there will be auditor eligibility, qualification, and other things, and also will come into place. Yeah.
Yeah, sure. But the first 2 points, right, what Kinjal has on a slide, first two, data landscape and the high risk processing activities. This is where the maximum amount of opportunity also will lie. Making the data inventory, writing what is the legal purpose. It's a very detailed, very granular spreadsheet that you have to basically map, even like your vendor's name. Nothing is automated. It can be automated slowly, but You have to understand the process by sitting with the business processes, business process owners, and every year they need to complete, the business owners need to complete the data protection impact assessment. The DPO will just approve it, but a lot of work is shedded down to the business head owners who understand the process really well.
Yeah, that's right.
And also, obviously, the IT,
Indian-
how IT supports all those business processes are extremely important as well, where privacy impact assessment on applications become very important as well.
Only thing is, I have a great concern about the smaller companies, startup companies, medium and enterprises companies, etc. How they will actually cope up and how they will get equipped to this sort of the level unless
think-
they upgrade the IT services, support, etc. and other things.
So now I think that's a very, very good question, Professor Bala. And I think that's we need to define uh, the the definition of startup, right? So Lenskart is also a startup, right? And we are also a startup, right? So the government does not want to like really stifle the innovation also of startups. So they are actually going behind they're gonna go behind the big guys first. Not saying that they won't come for the startups, they will come to them, but they don't want to stifle innovation of startups either right now.
Okay.
Yeah. Kinjal, how many slides more?
This is the last one.
So
Yes,
that we
I think
can do
I only wanted
questions.
to cover that the largest opportunity is in the data protection framework,
Yeah,
defining
yeah. No,
defining
just to say
Yeah.
that because we have not many questions, so I just want to clarify. Yeah, please go ahead.
No,
defining the
no,
framework.
lot of things he has actually answered the questions also. So we can take it. Yeah.
Yeah.
Yep, Mr. Ibrahim, go ahead. You want
So the first two part, right, then mapping the data landscape and identify high risk processing activity and doing a DPIA. This is where the risk come out. Like, what is the risk? Then you can keep monitoring the risk, either accept the risk or transfer the risk by taking insurance or applying a control framework. But the identification of the risk will only happen with the DPIA, which needs to be done on an annual basis. So that's a huge service-oriented, heavy engagement project, if I may call it. Which starts after the mapping the data landscape, right? The ROPA. I mean, anybody can see a ROPA template online. You can see it, or you can share it at a later time to see what actually goes in collecting that personal data. Yeah, I think Jill, you can move ahead.
So after the a committee is established where governance where data protection is taken in as a governance function, um, and various functional heads such as legal compliance, IT, HR, product risk, internal audit, etc., are part of this particular committee that helps kind of put in place this particular framework in the organization. The organization must appoint key roles also. So they must appoint a data protection officer, which is mandatory for significant data fiduciaries, a grievance officer, mandatory for all data fiduciaries, and they must designate a single point of contact for data protection board, any kind of communication with the data protection board. Then they must do data discovery and risk mapping. As Mr. Ibrahim mentioned, that this is one of the most important steps. It creates a defensible living record of personal data processing. It identifies category of personal data collected, sources, purpose of processing, legal basis, if there is consent or permitted use, storage locations, retention periods, data processors, vendors, etc. It must be mapped in data flows in when it comes to collection, processing, sharing, storage, deletion. And this allows for this creates a personal data inventory, identifying categories and risks associated with all of these data processes. Now, once this data has been mapped, it the company must identify and tag it with the level of risk associated with this data. So, for example, children's data is a high risk data, large scale profiling, behavioral tracking, automated decision making, cross border data flows, etc. are high risk processing data which must be treated with more care and attention. And more controls must be put in place for such kind of data. Then they must also have legal basis and consent architecture. So for to ensure that every processing activity has a valid legal ground, and you're not just collecting data and dealing with the obligations that come with this additional data, and you're limiting your collection of data to the processing activity that is a valid legal ground. So for each processing activity, it must confirm whether it is based on consent or permitted legitimate use. And if there is any legacy, if there is any old data that has already been collected, is there any unjustified purpose? If not, then you can just go about deleting the same and not continue maintaining this particular data. Then coming to notice design and transparency, as I mentioned, notice is one of the requirements under the act when you're before or when you're collecting data. The company must ensure and draft a layered purpose-specific notices covering data categories, purpose, retention, sharing, rights, grievance mechanism, etc. as required under the law. It must be clear, accessible, etc. Then they must have consent management system. They must make consent provable if questioned in law. Granular, which means for individual categories, the consent can be provided. It's not a blanket consent, and withdrawable. So they must implement affirmative consent capture, purpose-wise consent, which is an easy withdrawal mechanism. They must ensure that there are backend systems that log these consents, that timestamp actions, they link consents to processing, and prepare for consent manager interoperability, if any. Then companies must also look at data principal rights and enable those. So, for example, um, eh, you know, um, enable rights for data principals to contact the fiduciary when it comes to access, correction, erasure, grievance redressal, nomination, etc. So they can build standardized request intake channels when it comes to data principals, automate wherever feasible, train teams to handle rights and requests sensitively when it comes to data principals, and put in place these kind of SOPs. Then coming to processors and data processors and vendor compliances, the fiduciaries remain the ultimately responsible even when they are outsourcing certain data processing. When it comes to data processors, they must update contracts to include purpose limitation, security obligations, breach reporting timelines, deletion on termination clauses in their contract. They must conduct vendor risk assessments and monitor processor compliance periodically. When it comes to security, breach, and lifecycle controls, company must ensure that there is reasonable security safeguards. So they must align cybersecurity measures with data sensitivity. They must implement access controls, encryption, logging, incident response plans, etc. In case of personal data breach, the response must be speedy, transparent, and evidence-based. They must define breach classification thresholds. So, if say a breach of say one line item is probably gone out, then that might not require this thing. So, the defining of thresholds that are classified as a breach, establishing reporting protocol to the data protection board and affected data principals as required under the act, and putting in place breach response SOPs. When it comes to retention and erasure controls, so the company must define retention schedules as per purpose. So once the purpose has been achieved, then the there can be systems in place where the data relating to that particular purpose is deleted and erased, and that automate this can be automated, and it must also ensure that the data processor side data is also deleted. Indefinite retention is a direct statutory violation under the Act. Then there must be training, audit, and continuous compliance under the Act. So there must be organization-wide training, role-based training when it comes to HR, sales, IT, customer support, etc. Regular refreshers when it comes to this training, awareness for people that are collecting such kind of data. There must be internal audit and assurance to ensure and test that there is consent validity, rights of data principals have been handled correctly, and breach readiness in the organization. There must be regulatory engagement and documentation to ensure that the organization is inspection ready. So they must maintain policies, logs, decisions, risk assessments to prepare the organization in case the data protection board inquires for anything. So um, taking into account all of these, actionable steps, DPDP Act is not just a privacy policy law; it's a governance, accountability, and power rebalancing statute. And this I mean, going forward, it'll be very interesting to see how this takes shape as the time goes by, and how everyone in the country is impacted when it comes to data protection in India.
Great, Kanjal.
Thank you.
Very nicely you put it, everything encapsulated in a possible things. Very great. Now let us quickly go through the various questions. DPTA is saying about the data protection board appointed the concern manager as a significant data. Can you actually go aspect on the data subject right application? I think this she has covered enough, so we don't have to see this. Do it cover the accessing of the location and the contact access, as many applications do not go ahead without the access of the location contact. He has given the Ola and Uber. Because again, it is a need base, I think, if I'm not mistaken, if I go by what our panelists said, it is a need base because you want to be picked up at your place. Unless you provide your information where you are located, you cannot be picked up. So it is a need base. Only thing is the sharing of the information, etc., will be restricted. That is the only thing. Am I correct?
Mr. Ibrahim?
Yeah, and recently, I mean, I was also surprised, just drawing a parallel. I was recently sitting in an Uber and then I was speaking to the driver and it automatically said that they're going to be recording my conversation without my consent, right? For purpose of my security, right? So that's a purpose that is, again, can be argued. They don't need my consent because they are worried about my safety. And that is a business purpose. They started recording my voice without my consent, right? So there are caveats and nuances to that as well. But most of the location would be considered a kind of a sensitive data. Those organizations could be considered significant data fiduciaries.
Somebody has actually shared the information. Some of the countries even asking your nationality and the place, saying there, etc. and all this thing will be also considered. That's what he is sharing it actually for information. It is a different practice in the other countries. And then 18 months after, should the May 13, 2026 or May 15, 2027? I think as of today, it is May 26, I think. That is what the law says actually.
No. It's basically the first is in November 2026 and then it's May 2027. 60.
Okay. It was in a PPT. There was a mistake. Instead of 26, I have corrected. I said that it was typo error.
Okay.
I answered that. It should be May 26.
Just a fun fact is I don't know if you guys have been reading the newspapers. It's been there that the MeitY is trying to basically shrink the deadline further from 18 to 12 months right now, right? And industry body is saying that anyways, 18 months is a lot of time. It could be wrong workflows and which can cause more breach, right? Because pushing to technology has a big risk.
Somebody is sharing the information. I think recently India had signed or broadly drawn consensus. And then it says co-location of the data or close away, giving the location and maternity, etc. and other logic. Okay. So my location is a personal data. So if I vacation in Mumbai, I am recurring to my location. Access by the Ola or Uber is actually under the protection granted by the Data Protection Act.
Yeah.
Many times people give consent for so many prints hidden in the law. That I think you explained actually. You talked about the cookies and other thing and all. You talked about it. Even the collection information through the chatbot and the cookies are also considered. Yeah, that you also said actually.
Yes.
Can an employee ID or Mediclaim ID is considered personally identifiable data? Personal that also we talked. You talked about the insurance company and gave the example, etc. and other thing and all. So what is the extent of the compliances to be followed that she has put already? She has given the roadmap also. Which organizations will be
No,
covered
they are
significantly?
telling, say, a
Yeah.
small firm, which Mr. Ibrahim said that they have to work out on the
Yeah, yeah.
definition of small and all that.
Yeah,
Because
that
that
we are
is,
covered actually. I raised the
everyone
specific.
is talking as on today.
Yeah, I raised the basic question. In fact, he answered. Initially, it will be for the big four, but it will travel down to small. Yeah.
Yeah.
Because as I said very clearly, it will be difficult for the smaller firm and the medium size companies and other thing and all to put, because they need to the IT support. They'll have to put a lot of things. All those things. It's going to be tough job actually for them, especially whether they will concentrate on the business. They will concentrate all these things. That will be the larger question. Okay. Which is the organization will be covered with the significant data industry?
Data fiduciary. Which organizations will be covered in significant data fiduciary?
That will be only reported by the Data Protection Board. Only they will notify. Right now, what we know is that organizations that have large volume of data and the breach of such data could cause grievance to the data principle, right? Which could be your health, medical, financial information. So it's pretty broad. We have to wait for the notification, but most of the NBFCs, BFSI would be considered, and even healthcare, right? Hospitals would be considered significant data fiduciaries.
I think next question is putting the legal firm, professional, etc. that we discussed actually. They all will come under that. Then further considering that such firms routinely collecting processes and harder effects personal and confidential information in the course of professional engagement, what internal compliances measures and statutory obligations are required to be implemented to ensure adherence of the DPDP Act?
A lot of things are required. I mean, that's a very broad question. Is the question more around the roadmap? Like, what should they do when?
Correct. That's what it looks like, because when the professional, when they are collecting a lot of data, etc., for the various purposes, what should be? That's what he is asking. And she has put the roadmap. Actually, we'll have to, as we go along, we'll have to take, because the only thing is you have to ultimately protect the confidential information, but not doing anything which is not warranted. That's what I think.
Basically, Shilpi is asking what all CA, CS, and other professor has to take care. Shilpi, I think that will require a further guidance from our institute also. And also that because but basic thing, Mr. Ibrahim, that all this professional, you can give the guidance, the basic idea as such, when they are collecting data from the clients for doing their statutory obligations.
I think all the professional bodies will come up with the guidance note actually. CA, ICWA, CMA.
This is my opinion. This is my opinion, right? If
please.
Part of in the US they had Sarbanes-Oxley, which was process oriented, and they had one part of it which was IT related testing, right? That organizations basically need to do, like access control or change management or disaster recovery, business continuity. All that, it'll become a part of like a checklist which organizations will also need to do on an annual basis, right? And I think that's where the biggest opportunity for CA firms, right, would be there to do those annual audits.
Yeah. Next year onwards, it is going to be one of the more audit firms. You'll be a lot of opportunities will be there for the people. Yeah.
But right now, see how they basically the design of control and then testing of control. Right now, there's no control only, so most of the attention is going into designing the systems and the people and the processes, right? Re-engineering them.
Yeah, right.
Yeah.
What about the existing law? What about the existing law regarding data? Will it be overruled by this, or it will remain
legal?
DPDP will supersede most of them, but if the if the sectorial regulation is there, For example, like banking wants you to store data for 10 years. The other, and if a data principal says that come and delete my data, you cannot delete it. You have to basically, go with the uh, financial regulation.
I think
Friends,
probably,
one rule of interpretation is there that whenever there are two law, you have common law and you have sector-specific law or a regulatory bodies, regulations, and as such, you have to follow the stricter rule.
The
That is
stringent
a
one,
simple
correct.
thing.
not
Follow the
only that,
stringent law, that is compliance.
not
These
only
are simple
that,
interpretation.
Correct.
not only that, any organization, there are permanent records and there are records which are periodical. So permanent records cannot be erased at all. For example, in any organization, whatever you talk about the minutes writing should be there from the beginning till the end. So those sort of the things should be recognized, and again, sector regulation will follow for individual cases. Whether the entities within the group or related concerns can share this data or even no, it cannot be, because he said very clearly specific consent is required for sharing the data. He gave the example.
Yeah, I didn't get that
The
question.
question is whether the entities within the group or related concerns can share those data or even metadata.
They need explicit consent. I
Yeah.
give the example of HDFC Bank, right? You cannot.
Yeah, that's what he said actually.
Explicit
He
consent.
said explicit consent will be required. What are the steps of the company data industry should implement? That she has already given the roadmap actually. There are some free groups of the WhatsApp and Telegrams like blood donations, matrimonial job seekers, etc. Please narrate the liability of this group administrators and the group founder under the DPDP Act and whether they can be continued to operate as usual.
If they're collecting it, then I mean, most of these communities are very, very small mom and pop shops, right? We're talking about. So if they are taking that personal data over WhatsApp and everything, then they are responsible in a certain way. But they're too small. I need to understand the magnitude, volume of these. If it's a large community, right? Like the goal of personal information. So I need more information, right? If you're sharing personal data, you're collecting it. Are you giving them a data privacy policy? Are you telling them why this is being collected? So I need to understand that nature more, but it's an interesting standpoint.
But
they would be considered as data fiduciary though.
Yeah, but we can say since you are collecting, it is considered, you have to, at least that we have to create a understanding. If we are collecting data, we are responsible.
Because by definition, that is falling under the processing.
At least that we have to develop the responsibility.
Yeah.
Basic.
Next question is actually provision of the act and rule which is applicable that you said it is actually introduced in the phased manner, because November 25 and May 26 and May 27, that is the case. If data are graded based on casual data, personal data, and lengthy sensitive data, what are the provisions related to the protection each class category or classes? So sensitive.
It's saying, Mr. Ibrahim, that each data are graded based on casual data, personal data, and highly sensitive data. What are the provisions related to protection of each class category? Whether means there is a different level of protection to different level of data, that is kind of a question.
So the DPDP only talks about personal data right now. There is nothing like sensitive personal data and what have you.
No category.
The DPDP Act never talks about sensitivity. It only talks about the personal data.
The only place where it talks about sensitivity is that if an organization could be a significant data fiduciary if they are processing large volume of sensitive data, something on those lines, right? But there is only personal data and non-personal data.
Then the concern manager represents who? Data processors, or it's independent of anyone?
I think he extend.
It's supposed to be independent, right? Data blind, all those things that she had covered, being data blind and acting on behalf of the fiduciary for the data principle.
Our company started following the act because the act is under implementation. We'll have to start following it. That's the thing. It has already been notified in November 25. Does a third-party payment processor have to give me a privacy notice and get my consent if they are collecting my data through the platform of a Swiggy while I'm making a payment?
While making a transaction with a third party, are they storing your data or not, right? But I think Swiggy has started like telling you that Are we talking about like a payment processor, like a lazy pay or something?
That's what he's asking actually while making the payment. He's
Yeah,
taking this.
so they actually take your consent very clearly, or they must have taken it initially. I've seen the consent languages, especially for Swiggy and the third-party processors, right? They have they do start. They've actually started taking those kind of consents, but they're not supposed to share. They're not supposed to keep the data for with them for a long amount of time, right? Only supposed to do it for the transactional basis because they don't have any legal basis for keep the data.
Is concern manager is a separate professional or it will be a digital assistant?
It's like an account aggregator, right? Most think of it as an account aggregator that is registered by the DPDP board.
I have a question. It relates to the CFM. A CFM will be a data fiduciary as far as that employee are concerned, but a data processor for the audit has collected from the client. Also, let us say CA firm uses the AWS to store this data. So CA firm and AWS together are the joint processor for the company whose data has been collected, or will AWS is a downstream processor?
They'll both be joint processors with you.
Okay.
Processor or a fiduciary? Processor.
Processor. You're asking about the processor.
Processor. There's a recent Supreme Court judgment on the Meta. What about this information?
Meta and WhatsApp case.
Yeah.
So,
that is what we talked also.
There's a whole concept, right? I mean, of like fourth party, fifth party, when people are outsourcing the data. So all those maps need to be labeled out very clearly. Not only third party, like fifth party, sixth party as well.
Even when incorporating a company on MCA, the moment the company is actually registered, directors are bombarded with a
that should stop.
phone call, whatever. What do you believe? DPTA will have the impact.
Yeah, it will impact.
It will impact them. We'll definitely see a change.
Next question is thanks a lot. Next is there is a concept called social listening, where companies do know what we are actually searching on net. Yeah, that is there actually.
It depends on the cookies. I mean, the cookie browser. Right, obviously, they know what you're browsing. Accordingly, they will start showing you ads. Right.
Such a facility is unconcerned or practically done because we only give the concern, no? Because you say whether this time or all the time, every time when I use or you will using the application, all those things are there, but unknowingly something goes. Yeah.
But now very soon you will on every web page you will see that you should see very clearly a pop-up banner. You can go to Tata Volta's website and see how nicely they have a privacy policy. They have different regional languages. They will explain you what every cookie is, what it does, which is like important, mandatory, which is like non-mandatory, and a very easy toggle button. What each of the cookie does, they have to explain. Each website will have to do it now. Very few websites in India, including HDFC, Tata Voltas, are doing it as of right now.
There is one question, Mr. Bala, that with respect to consent, what are the acceptable modes of obtaining explicit consent as per this Act?
The mechanisms, you mean?
Yeah, what are the acceptable modes of obtaining the explicit consent as per?
I mean, it has to be like you have to give a portal. Most of the organizations will send them a text message with like with a link, right, which will be very individualized to them. When they go into that link, it will tell them what are the consents, what data they already have, and do they want to opt out of that as well. So usually it's that. It could be that's the most efficient way, right? I mean, you can do calls also, but who listens to calls, right? You don't want to listen to a call taking a consent. So either a text message with a link is best, because text message also has but all these things are not prescribed by the regulation. These are
not regulation. It's an act he is asking. It is not still to clarify. Yeah.
We are a dental lab who manufacture artificial dental prosthesis-based doctor specification. So what should we do to liaise with the concern manager?
The concern managers have not been registered by this thing right now, but there are a lot of organizations who want to be a consent manager. They've just prescribed what are the eligibility criteria for a consent manager, but the government has not made anybody a consent manager yet. not even the applications are started yet, right? Uh, yeah. So, but you
Yeah.
can take, but you don't have to take a consent manager that is registered by the board. You can take a normal consent manager as well, as long as you can. The law does not tell you that you have to take a registered consent manager, but most of the organizations prefer a registered consent manager because they feel that it will be less exposing them to risk.
Recently, TCS also onboard concern managers as per
Yes,
the
they have.
received info.
Recently they have come into the space as well.
In your opinion, would you take the consent from the nominee under MF or the insurance?
Mutual fund and insurance.
Yeah, mutual fund insurance.
This
Would
is
you take
for
consent
nominees.
from nominees?
Nominees is totally not for
No, you have to
this
take the principle,
relevant to
not
topic. It is about mutual fund and insurance nomination process. It's not for this data protection or data privacy or kind of thing.
No. He is talking about a consent. Will you take a consent from my nominee? Because you have to give the consent, not your nominee. That is what I understand the question.
You mean like a father putting the name of the children to
Yeah.
the nominees? Then
Yeah.
the children,
Correct.
if the children data is given for the betterment of them, the service is provided for the betterment of them. If you're buying a mutual fund for them, or you're buying an insurance policy for them, then if it's for the betterment of them, then you don't explicitly need that.
Yeah, next thing is he's talking about the emergency treatment that you already addressed it. Companies file from MSME, MSB one containing the PAN card details of the vendors. Whether this particular act complaints is triggered of such things with the MCA, any action required in this record, such as taking consent of the vendors.
Means basically what it is telling that you are under Companies Act, we are filing the form for MSME 1 containing PAN details of vendors. So whether any action required in this regard, taking consent of such vendors that we are filing.
Yeah.
Because their PAN details are also there. But if I say that way, that means that when they are giving us the right and direction to file MSME form.
Dipti, one thing is there. Abraham said initially, the companies have to redraft their agreement with the vendors, because once you are entering, because when they are proving the detail, you know MSME form is to be filed. So you should actually put an agreement in such a way. This also will be used wherever it is regulatory requirement is there. They'll have to reword it. They'll have to take the consent.
Ensure the compliances.
Law expect the specific consent that has to be built in the agreement. If the consent form is sent, but they do not respond, and the companies from the company's end, what should be done?
I mean, that's more of I would let a legal person answer that question, but there are different thoughts that people say. They say that, some people are saying send a couple of, do your best by sending a couple of, sending follow-ups, and probably some of them are saying that after 3 tries, send them a message saying that, we are considering this as deemed consent, but that is not something that's very distinct. Some people are saying you should put in a newspaper also, right? But you have to basically show this whole law is about an intent, that the organization has made a real intent, send them a couple of nudges to update their consent, but they haven't updated it. That's not the onus of the organization itself.
Is there a recommended maximum retention period prescribed for the SDFs categories?
You should not have data for more than the rule of principle is for a big principle of data privacy is a rule of data minimization, right? So not have, first of all, having data that you don't have a purpose. If you don't have a purpose for that data, then you should not have it, right? For example, take a intern or people who have applied for a job, you haven't given them a job and you don't intend to give them a job, then you should delete that data immediately. Right, so that data minimization policy has to be applied to every process logically, accordingly.
Third-party audit is necessary of the vendor processor.
Third-party audit
necessary.
It is not mentioned, no, in the Act. Third-party audit of a.
Audit will like
data processor. It is mentioned that the data fiduciary will be responsible. Data
Yeah,
fiduciary
processor.
will be responsible if there's a if there's a breach at the data processor's end.
Processor. He
Yeah,
is responsible.
data fiduciary is responsible because he's taken the data from the customers. He's decided the means and purpose. He's taken the consent. He's giving it to the data processor. So the data fiduciary needs to basically make sure that
It's his prerogative, or you can say the liability or decision, whether he wants to do audit or not, or rely on the document provided.
Dipti, we are closer to 1:30.
Yeah, that's why we are too little fast.
Technically
YouTube
making it
ten-
to the principal recipient, technically
Very-
marking CC to an unintended reception is also a breach. Yes, you have to take all the care.
Yeah. Website Mr. Ibrahim has mentioned, but we don't have time to try. You have to try yourself.
Please mention who are considered the children and the DPTA. Children, is there any definition is there? Who are considered as the children?
I think 16 or below.
Okay. What procedure can be fiduciary set up to have the verifiable consent that we are talking about it?
Sorry, what Kinjal you want to say?
Yeah, no, children is 18 or below.
18 or less.
I don't think government will restrict the dual responsibility. Yeah, that's it. Dual responsibility today it is possible.
We
That is
discuss.
there. We discussed that. Do the chairman and the members of the data protection board need to possess certain qualification and experience so that they can properly perform their duties of the DPDP Act?
Kinjal?
I think probably the government will notify all these things. I think so.
Yeah.
In case of someone failed to pay the penalty amount, what is the recourse available if there is no imprisonment?
That government will.
No, it is not the question of reimbursement. Already there is a rule is there. If the amount is not paid, it will be treated as a, land revenue arrears in the revenue. Collector will be empowered to access all the properties, etc. That is already there actually. In all the acts it is applicable. That will apply automatically. Is there any provision in the DPT Act for a training of the chairman and the members of the board of the entire? Yeah, that we talked about it. Kyle, okay. DPT recording.
Yeah, liability of 200 crore. Yeah.
That also we talked about it. No, we talked about the liability of the 200 crores insurance, all those things we talked about it. Interesting to note that there is no compensation that can be awarded to the aggrieved data principal.
Data principles. Anything is there? No?
What?
Okay. Yeah.
Compensation.
There's only penalty for.
Interesting to note that there is no compensation that can be awarded to the aggrieved data principals.
Yeah. In fact, there's a fine of 10,000 rupees if they do a mischief, which is not there anywhere in the world. This is only in India because they think that, in India, they're expecting troublemakers. So to deter that, they have put a 10,000 rupee fine. No other privacy regulation in the world has that.
But no compensation.
No
provision.
Correct.
Oh my God.
To cover the non-compliant.
Then what is it? This is very interesting, Channa has pointed out, because data principal, you are protecting data principal and there is no compensation to him on the entire act for that data protection.
Yeah.
I think in India, we don't have class action lawsuit also, no? In that case, similar, that people can sue a company and get some benefit out of it. So I think similarly, I think there's no benefit to this thing, data principle.
And the companies that class action suit is allowed, and recent yesterday, 2 days back on NCLT has admitted first class action suit against a company. Yes, in India.
Next is the insurance. We talked about it, about the insurance. The penalty is considered more than the net worth of the entire being penalized. Yeah, that is there actually.
Net worth, more than net worth of the company.
Yeah.
Okay.
That's why we have to be serious in discussing all this.
Okay. Just join the WhatsApp channel. Excellent information. Yeah, okay.
What you shared, Mr. Ibrahim, that.
Yeah. Data breach addressing response procedure should ideally form part of the business continuity plan for organization. There's somebody.
No, not really. Right. This is a more of a privacy incident. This is different from your cybersecurity reporting also. This is mostly to do with personal data breach, where disaster recovery mostly looks at your, backups being lost or, DCDR site being down or some of that kind of issue, right? Replication issue, where you have a RTO, RPO time. This is mostly around data protection breaches, right? Because certain things need to be done when a data personal data breach happens. You need to get an independent forensic auditor also to basically see what is the recourse that needs to be done. Then the communication, to the data principals needs to go out by the communication team. How to manage the press. There's a whole we do a tabletop exercise with every different individual, which has to be incorporated into the data breach policy. So not disaster recovery, BCPDR is separate than this.
Mr. Bala, there are two, three
Yeah.
questions they are asking, NBFC, cooperative. So we'll take one question, which is general, that covered, Mr. Subham. Does the Digital Personal Data Protection Act apply uniformly to all entities regardless of size and scale? Or is a proportional risk-based compliance approach expected for smaller organization handling limited personal data?
I mean, we have the concept of significant data fiduciaries and data fiduciaries, right? And it basically, it is a risk-based approach, compliance approach.
And it is uniformly applicable to everyone, all organizations, whether
Yes.
it is that, right?
Yeah.
Yeah. So there was a separate question for NBFC and other things that is answered. If I'm NBFC and all that. Yeah, Mr. Bala. Because we are running short.
What is the complaint burden on the NPSC having no client interface?
The same thing I'm telling you, we have covered, it is applicable to everyone. And as regards the data, the difference we have mentioned. There is no
Okay. There's the Digital Personal Data Protection Act 2023 apply uniform that you talked about it. What sub-listed company that you talked about it? What is the role of the third party that also we discussed? Does DPDP Act apply processing for all the PAI within India? How will the CCC centers processing data bank office operation be affected with this legislation?
Sorry, Bala. Can you?
Yeah.
What is?
He says, does DPDP apply to processing of all PAI within India? How will the GCC centers processing the data back office operation be affected with this legislation?
It's
mostly, if you're talking about GCC, then you're processing usually outside countries data principals, data subjects, data, right? So then we have to be governed by those regulations as well. But GDPR and all those regulations have intercompany transfer, it really depends on the type of GCC we are talking about also. So there's something called as intercompany transfer, which makes it okay for organizations to share data between the entities which are, in different parts of the world.
I think, Mr. Bala, all the question I said, almost we have covered. It's almost 1:40 now.
1:40, yeah. It's been a very long session.
Yeah.
Only one question I will take now. Going by MSME question that we discussed, companies have to make a lot of filing with the MCA, SEBI, etc., which requires PAN number of the director, shareholder,
Same
etc.
thing,
in relation
Mr.
to the
Bala.
filing. Yeah.
Same thing, PAN number and all that. I said that now, everything we have covered now.
Yeah, that's all. I think so. Yeah.
I've seen that. Okay,
Yeah,
1:40.
Yeah.
People want to have lunch. Mr. Abraham will skip the lunch now.
I guess it's an interesting topic, right?
Yeah, very interesting.
Ibrahim,
Yes,
closer
sir.
to 155 people are still there in the session at 1:40. That shows the importance of the topic.
I'm glad the awareness is building up.
Yeah. Thanks a lot. Thanks a lot, everyone,
Thank you for having me here. It was great.
Yeah,
Thank you.
Mr. Abraham, it was wonderful. You're sharing knowledge, experience. We may have similar kind of webinar on the similar topic as more clarity will come, more thing, and we will surely invite you and connect you for further your guidance and sharing your knowledge with our participants.
Thank you so much. Thank you so much
Thanks
for
a lot.
having me here. Thank you, Kinjal. Thank you, Professor Bala. Thank you, everybody.
Ibrahim,
Thank
thanks
you.
a lot. Today, a lot of things I could learn actually from your sharing. It's very interesting session. I personally enjoyed. I'm very sure participants also would.
I'm glad.
Thanks
I'm glad it resonated. Thank you so much for having me here. Thank you.
Thank you.
Bye.
Thanks, everyone. Thank you.
Bye.